Hello everyone, and welcome. Today we are tackling a very common and important question: can a foreigner own land in Indonesia? It's a topic that sparks a lot of interest, especially for those dreaming of a home or investment in this beautiful country. Let's get straight to the facts. The short answer, regarding direct freehold ownership, is generally no. Indonesian law reserves Hak Milik, which is the freehold right of ownership, exclusively for Indonesian citizens. Foreign individuals cannot hold this type of land title. This is a fundamental principle of Indonesian land law. However, don't let that discourage you completely. While direct freehold ownership is not possible, there are several legal and secure ways for foreigners to control and use land in Indonesia. Here are the main methods. 1. Hak Pakai, right to use. This is a very popular option for individual foreigners. It grants you the right to use land directly. You can build a house on this land. The initial term for Hak Pakai is typically 25 years. It can be extended for an additional 20 years, and then often for another 30 years. This right is registered in your name at the land office. It provides a strong and secure legal basis for your property. 2. Hak Sua, right to lease. You can lease land from an Indonesian owner. This is essentially a long-term rental agreement. These leases can be for substantial periods, often 25, 30, or even 50 years. You usually pay the full lease amount up front. This method is widely used for villas, businesses, and personal residences. It offers flexibility and security for the lease term. 3. Through a PT-PMA, foreign investment company. For larger investments or commercial purposes, foreigners can establish a PT-PMA. This is an Indonesian legal entity, even though it is foreign-owned. As an Indonesian company, a PT-PMA can obtain various land titles. The most common are Hak Guna Bangunan, right to build, and Hak Guna Usaha, right to cultivate. Hak Guna Bangunan allows the company to construct and own buildings on the land for a specific period, typically 30 years, extendable for 20 years, and then another 30 years. Hak Guna Usaha is for agricultural or plantation land, with similar terms. This method is robust for business operations and significant developments. 4. Nominee arrangements, a word of caution: some people explore nominee arrangements. This involves an Indonesian citizen legally owning the land on behalf of a foreigner, often with a separate agreement. However, this practice is highly risky and is considered illegal under Indonesian law. The Indonesian nominee could legally claim the land at any time, leaving the foreigner with no legal recourse. It is strongly advised to avoid nominee agreements. Always use the legal and registered methods mentioned above for your safety and security. So, while direct freehold ownership is not an option, foreigners have several legitimate and secure pathways to control and use land in Indonesia. Always seek professional legal advice from an Indonesian property lawyer before making any decisions. They can guide you through the specific regulations and ensure your investment is safe. Thank you for watching this video. We hope this information was helpful and cleared up some confusion about land ownership in Indonesia. If you found this video informative, please give it a thumbs up. Your support means a lot to us, so consider subscribing to the channel for more valuable content. We'll see you in the next video.